Hello. My name is Bob. The moderators of our panel today on global intellectual property, predicting trends. It's not on? It is on. Right? I think so. Yeah. My co-moderator is to my left, who is the chairwoman of the Russian Intellectual Property Court. And our panelists are, we will introduce as we discuss the topics, but here is a list on the slides of today's presenters. And what we're hoping to do today is to have a dialogue on this interesting topic, and we've chosen a number of topics to have discussions on that include an overview of the American patent system by Judge Lin, who is, we're fortunate to have with us. Judge Lin is a judge of the United States Court of Appeals for the Federal Circuit. We will have a discussion of Russian patent law by Chairwoman Novoselova to my left, who is the chairwoman of the Russian Patent Court, and Vladimir Korneev, who is across from me, who is the vice chairman of that court. And we will have discussions of various topics, including the enforceability of IP law internationally by practitioners in those fields. And before we begin, Chairwoman Novoselova, you wanted to make a few remarks?
Thank you very much, Mr. Huffman. I'm very happy that we have an opportunity during the legal forum in St. Petersburg to discuss issues related to the enforcement of patent law and to discuss those issues or problems that emerge in the field of regulating new achievements or new inventions that we come across in our daily life. There is significant difference between the area that we are working in, the intellectual property field, from all other fields of law. The thing is that our colleagues that work in the field of civil law, criminal law, they work in a system that was created rather a long time ago, and this system is improved and adjusted, adapting it to modern realia. But when we talk about intellectual property rights, we come across a subject matter that never existed before. And I think this is the only area about which we can say that we are creating it right now. We're not upgrading it. It is being created before our eyes, literally. Therefore, specialists in the field of intellectual property are people who are at the tip of progress, trailblazers, if you will. Our roundtable today has a very interesting title. We're talking about trends of development of intellectual property law, and to relieve Vladimir from speaking on this topic, I would like to say a few words about the law, the Court of Intellectual Rights. It's one of our topics. Speaking about trends, speaking about directions of development in this area, we cannot but mention the protection of intellectual property rights by means of law. And therefore, the intellectual property court that was created in the Russian Federation and started working last year on the 3rd of July. It's probably the youngest court in the world. It's not even 1 year old. So this court is very special in terms of its frame of reference and competences and tasks at hand. It is probably the only court in the world which unites functions characteristic of patent courts that deal with issues of legal or protection, using German patent law as an example, and also the court performs control functions, cassation functions over the decisions of courts of arbitration related to issues of infringement upon rights of intellectual property. So this combination in one court, issues related of the protection of rights and violations at the same time of rights, this is a unique experience world over, and we think that this experience so far at least has been showing quite successful results. It's a very successful way forward, and I think that in the course of our roundtable discussion there is no need to tell you how many cases we have already processed, what kind of issues arose on the way. We will talk about it during the discussion, but our court, when it started operating, by now has already formed around the court a rather powerful infrastructure, if I may call it so. We have very good contacts with the academia. We have a very strong expert and vice counsel operating under the court that includes well-known international lawyers, which is a rare case for courts, but we thought it is absolutely indispensable, because when we work in the field of intellectual property right protection, we need to take into account global practice and experience of other countries when we form this or that position in the court. We have very good contacts with Russian academic institutions that work in this area. I'm happy to see here our colleagues from the private law university, who help us when we need an expert opinion. They are not the only experts with whom we work and contact, but I would like to use this opportunity, since they're here, to thank them for their assistance, for their cooperation, and for the work they're doing. We have very good contacts with institutes and universities. We established all those contacts because we wanted ourselves to resolve issues of education in the field of law, how lawyers in our field need to be trained, and we are very active on organizing internships in our court of lawyers who specialize, lawyers who are specialized in the field of intellectual property right. At the same time, we are in contact with technological academic institutions. We provide them certain methodological support, and we also widely use the technological and scientific knowledge that we may gain or receive from people working at such universities. Before our roundtable discussion, we talked a little bit about how you can attract experts when you are dealing with the disputes primarily linked to patent law, but not only in this area. We compared models of getting technical experts involved in dispute resolution. As of today, we have two opportunities in this area. We can have an expert on staff at the court, but it is rather difficult to implement currently for various technical and organizational reasons, but we will resolve that problem. We have a very good expert, one expert who works at the court as a staff member. He is an expert in the field of patent law, and she is helping us a lot when we form the team of experts whom we attract from the outside. Now the list of experts who are sort of accredited, we are not accrediting them really, but we form a list of experts, which is an open list. It is published on our website, and judges can choose from that list an expert who can be involved in resolving this or that specialist issue. This work is not over, it is work in progress. We are looking for experts in a variety of fields. This list is going to grow, and I'm very hopeful that our colleagues, non-lawyers, let's say, will understand our requests and participate in the work of our court. So I think that together with the Ministry of Justice, in the second half of this year, we will hold a conference that will be devoted to the involvement of technical experts in patent-related disputes. And we will discuss various ways used in other countries and try to find the optimal option. From the point of view of issues that were discussed, I cannot but touch upon that over this short period of time the court has worked out a position towards the main disputes, as they are called, between owners of trademarks and those in whose name the main name is registered. Very widely spread disputes. There are certain approaches how to resolve them in Russia. Such disputes emerged not long ago, and the system of courts was rather difficult for courts to resolve such kind of disputes. We have prepared summary guidance, so to speak, in which we expressed our positions with regard to such kinds of disputes. The first issue that we discussed, and it was a very serious issue, we discussed that on our advisory council meeting, about the misuse of rights, abuse of rights, unjust competition. The topic is very important for us because it is between kind of the intellectual property law, procedural law, anti-monopoly law, general provision of civil law. So this combination required very serious analytical work, and those recommendations that were worked out by the court and posted on our website will be helpful and be of interest for lawyers who work in this kind of area. So we are limited on time. I am not going to take any more of it. I would like to ask everyone to actively participate in our discussion. The round table will be over and the issues will remain. This we understand, and I would like to make the following suggestion. The Court for Intellectual Property Rights has established a journal. It is called very simply the Journal of the Court of Intellectual Property Rights. The clearer the task is, the clearer the contents is. You all have an invitation in which there is an address, and if you have any questions, if you need to share your opinion about case law, not only of the Intellectual Property Court, we will be happy to look at your materials. And the journal doesn't exist in a paper format, in hard copy. It is a website, no subscription, absolutely accessible for everyone, not only for participants from Russia, but also from other countries. So access is absolutely open, and you can look at all the materials. We update the site very regularly, so we invite you to actively participate in the work of our web journal. And now let us get down to business. I would like to give you an opportunity to choose any of the experts. Who is going to give the floor first? I would like to suggest that you do it, but I, myself, if you don't mind, I also have a proposal to give the floor now to Igor Drozdov, our great friend, the friend of our court. Mr. Drozdov works in the field of enforcement, law enforcement of various regulations related to patent law. He can tell about various issues and ways of further development, and we will see whether we are choosing the right direction for developments. Thank you very much, Lyudmila. Of course, over the past 2 years, we have been discussing a lot the trends and the ways of development of patent legislation. If we take patent legislation as such, and do not talk about copyright law, and we have accumulated a number of conclusions which I would like to share, and probably we could discuss them here. I would like to tell our international participants that Russia is quite unique, because here we do not discuss issues of law enforcement, how the patent law is enforced in real life. We're not at this stage yet. We do not have a lot of patent disputes as such. The main problems in Russia, problem in Russia is that patents are not in the turnover. The results of intellectual activity, intellectual property rights are not commercialized. And therefore, we've been thinking about how to ensure this commercialization of intellectual property for our scientists, researchers. Patenting as such, and we discussed this week with the universities, is a form of reporting to their bosses, to the government. They're showing that they're doing something. They say that we applied for so many patents, and this is a kind of a reporting. And at the same time, it is a recognition as a medal, I have 150 patents. It's like a order.
But of course, such academics and researchers are not really worried about commercializing their patents. And they might have some psychological misunderstanding when they are critiqued that they didn't have their patents commercialized. And some academics and researchers also claim that for some reason they are not getting money for their patents. And probably it dates back to the Soviet legacy, when the compensation and remuneration for patents was quite different, like paying bonuses by the employer to the employees who received patents. Now this chain of getting remuneration for patents is much longer. And the inventor can only make money when the patent is being used commercially. And this causes misunderstanding, especially from the older generations. Younger people look differently at this. And then there's a big challenge in that there is some mistrust in making money on inventions. We analyzed various financial support mechanisms and legislation. More or less this works in Russia. And the main problem, the main issue, as experts believe and universities also believe, that there's simply no confidence and trust that they can make money on patents. And for my foreign colleagues, I can tell that under PCT system, we have about 1,000 applications for patents in Russia, which is miserably small. And unfortunately, we still do not see any real prerequisites for any significant growth in the number of such applications. But of course, we are watching and following the international trends. We analyze them, and we are thinking how Russian legislation can be changed, and maybe some changes can be done also internationally. The biggest issue here is, as Lyudmila mentioned, is that Russia is again unique and not like international partners. Intellectual property is not within the domain of the anti-monopoly, antitrust legislation. In Russia, there is belief that intellectual property is a monopoly of a special kind that cannot be restricted, and anti-monopoly legislation is always about restrictions. So we have some debates going on, and of course there are different opinions even here in the audience, but we have prepared some changes to our existing legislation, and the anti-monopoly agency claims that intellectual property is just like any other monopolistic property and should be regulated by the anti-monopoly legislation. So we need to think about what kind of enforcement or regulatory mechanisms should be in place, so that we really do not do harm to intellectual property, and we need to follow international best practices as well. One other thing that we are discussing, again, this is an issue probably, or a challenge for Russia, which is not really very high on the agenda. The thing is that we have very low patent activity, and the patent system should be friendly, should be user-friendly, should be friendly to those who hold patents. The existing patent system was established quite a long time ago, and it requires some expert examination, and in Russia it may take up to a year. Abroad it can be even longer to have such an expert examination report, and for some areas this is too long. For example, in medicine, it may take several years from an idea to getting a patent, but that is okay for medicine because you have to go through certain procedures, tests, clinical tests, etc. But if you take IT, this is not acceptable to have such long period between idea and patent. In practice, it means that companies simply do not use this institution of patents. It is useless to them. They ignore this institution, and it is better for them to have a claim to see some activity from a patent holder rather than getting a patent for that, or they are looking for other models without using intellectual property norms to operate. So we really need to think how expert examination can be accelerated. Of course, there's another challenge coming up, because expert examination and expert is a much more difficult business today, because you have a lot of information, although easier to handle. But if you take some Reuters database, you would have 150 million units of information there. I mean, there's no guarantee to handle and process data ideally. So I don't think that there's any guarantee that something can be contested in court or appealed against, that this or that development or invention is something new and has never been suggested before. In Russia, we are actively discussing a new object of a transformed industrial design or sample. And legislation in Russia was changed recently to bring it closer to Western standards, and now there's an opportunity to register the so-called industrial design objects in Russia. I think there is a lot of capacity in this market now, because unlike inventions, where it takes a very difficult path to commercialize the patent, with the trademark or with the international design, it is much easier. If you have some industrial design or trademark, you would have it on your product, and it can be it is easy to register it and use it. Again, it is much more difficult with inventions, because you need to find somebody who would acquire a license for such a patented product and then commercialize it. So many steps and obstacles on the way. In this sense, industrial design is probably an object which can be in demand, and the market for such products will be established. But again, even though there's a simpler procedure to register such objects, and we discussed various mechanisms in seminars with the World Intellectual Property Organization colleagues, but even our colleagues from WIPO claim that sometimes it's quite difficult to protect intellectual property. Young people can use iPhones to photograph something and perhaps send it for protection. But right holders, patent right holders, need to register their priority, not really thinking that they invented something totally new and getting this recognition from the patent office, but they still want to primarily register the priority, and this desire goes beyond patent law, and the copyright holders and intellectual property right holders, for example, for movies, they want to register the priority. Patent holders have this opportunity to have the priority registered, but now those, say, film directors, they want to register the priority because otherwise it would be difficult to prove that the right of this film director would be infringed upon. Also, you can have various protection mechanisms, elements of trademark, or if you take architecture, you're talking about a different protection scheme. So I think that this perhaps a mix between patents law and expert examination and the loss of trust to expert examination, plus, which is not something typical for Russia, but for the US, the growth of patents, all of this mix leads to numerous patent disputes. Some companies do spend for the legal protection more money than for the inventions, and we don't think that this is really normal. Now, the trends that I'm talking about, I think, are quite visible, and of course we would appreciate to share the experience of our foreign colleagues. And the last thing that I wanted to mention is that we don't think that innovations are possible without certain exceptions from the intellectual property rights system. In copyright, you have some public domain usage of intellectual property, copyrighted material. In Russia, this exception system is more closed, and in the US, for example, you have a set of principles. So if your use for a copyright copyrighted material is in line with those principles, you can use this copyrighted material without any consent from the author. In Russia, it's a bit more closed, but I think there should be some exceptions for education. For example, because no innovations are possible without qualified personnel and staff. With the help of the internet, even in the distant corners of Russia, technologically speaking, you can have access to any research materials that you need for your education, but the restrictions on copyrighted material, and by the way, such restrictions are even tougher in Russia than in the US, but because of such restrictions, you simply cannot use virtual libraries, or you cannot really digitize any printed material that you can borrow from a library. It looks like we are in the 21st century, but otherwise we are still living in the 20th century, because you have to go, for a student, he or she needs to go to Moscow, find a book in a big library and then use it. It's not possible to do it distantly, at a distance. Plus, of course, any profit for the copyright holder is a myth, because, of course, no student would go abroad or to Moscow and would never pay any money to the copyright material, to the copyright holder, but because it's too expensive, and the profit for the copyright holder would be minimal. But there we restrict also access to education and training. I think that's quite a topical issue for those countries who are trying to catch up. For the developed countries in the West, this game of intellectual property has been played by them for hundreds of years. Frankly speaking, we have joined this game in the last 20 years, maybe. So the companies of the leading countries, they have a much bigger package of intellectual property than us. So we cannot really dictate anything, but we should really use some general principles of good faith competition, and we can then form some balanced rules for ourselves. Thank you. Thank you indeed. I think it's a very good beginning for our discussion, since we highlighted some of the topical issues for our agenda, also some delicate and painful points, some issues and challenges that we have in Russia today. Perhaps our American colleagues would like to comment on some of the thoughts expressed, and who would like to take the floor?
I'd like to talk about the international business environment and how various national intellectual property systems interact with the international environment. This topic, I think Judge Lin is going to make a few observations on this topic, and then David Korus, as one of our panelists, will also talk about this topic, and we can have some dialogue on that. Judge Lin?
Yes, thank you. And first, let me thank the Ministry of Justice for inviting me to participate. I'm delighted to be here and to be part of this panel. I found the comments of Chairwoman Novoselova and Igor very interesting, because here you are building a relatively new system and struggling with all sorts of new questions that are arising. And in the United States, of course, our patent system, our intellectual property system has been with us from the very beginning. It is, the intellectual property idea is so firmly entrenched in the American psyche that it is part of our Constitution. So it has been with us from the very beginning. And yet our system, after all of these years, we too are struggling, and in many ways rebuilding and forging and looking for new directions. Why? Because the world is changing. and the world is changing at an ever-increasing pace. For the United States, with such a strong tradition of intellectual property, our view is that innovation is essential. Innovation is essential to the health of our economy. And the best way to stimulate innovation is to have an effective, efficient, fair system of protecting intellectual property with courts that are respected, that have a strong view of the rule of law, and will vigorously enforce the rights that are obtained. The interesting thing on a global scale is that, of course, while business for the most part is no longer national in scope, it's global. And global business knows no borders, but yet the national systems still exist. And that presents a series of very interesting challenges for business and business leaders, and for government for that matter. In the United States, because the pace of change is so fast, and the developments of new technology, nanotechnology, biotechnology, information technology, these things are happening so fast that our Congress has had to rethink the laws to see whether they have kept pace. Congress 3 years ago passed the America Invents Act, the so-called AIA, which was a major restructuring of our intellectual property law, the first major restructuring since 1952. And we'll discuss some of the details of the AIA a little later in our roundtable. The Federal Circuit and the Supreme Court also have made some sweeping changes in the last few years, all in an effort to keep pace with all of the changes that are just happening around us. I think all of these changes have prompted governments to rethink what they're doing, have prompted business leaders to rethink how they conduct business. And I think recognizing that there will always be different national systems around the world suited to the local needs of different countries, I think it is very important to have forums such as this, where leaders from all across the world can come together and have this kind of an open roundtable discussion. So for me, as a judge, I'm so pleased to be here, to have the opportunity to get to know my colleagues on the Russian IP court, and to hear from the business leaders around the world and around the table here, so that we can share best practices, we can learn from each other, and hopefully find some constructive things to improve the future. So those are my very brief opening remarks. And again, thank you.
Thank you, Judge. David?
Well, I would also like to thank everyone for my presence here, inviting me. For the judges on the panel, I think it's a rare opportunity to have you as part of the panel sharing your thoughts on enforcement, distinguished colleagues from business, from the foundations, important foundations in developing in Russia, and other corporations. I'm very pleased at what I've heard already. I can see that Mr. Drozdov's comment that referring to IP as a game, and that Russia is embarking on this, and the job is done in the rest of the world. Well, we all know that in Russia, not only are Russians excellent in terms of innovation and new technology, but you're very good chess players. And I would submit that that intellectual property, if nothing else, is a game of chess. At least from the business perspective, it is. Now, I'm coming to you today wearing two different hats. The first hat is really as a chairman of an organization called the International Chamber of Commerce, The International Chamber of Commerce was formed in 1919, largely to represent the interests of business. We have 6 million businesses as members around the world in 130 countries. I'm chairman of the IP organization, and we have the privilege of working with national chapters made of gentlemen like yourselves and ladies who are professionals, either with law firms, academia, or businesses. And the whole idea is to learn what's necessary in their minds in each nation to help out in the journey for developing intellectual property, which every country is on. And so I just wanted to begin with that, and even though it may seem rather wordy and lengthy, I promise not to take all that time with the rest of the presentation. On the screen you see, just for purposes of the translator, we have we had 3 points up. The first one was global perspective on intellectual property, and it's really a philosophical discussion from the perspective of business. How important is it to understand what's happening around the world in intellectual property? Secondly, the role of in-house counsel in promoting information management and security. Well, it's said that we are in the digital economy, and I would submit that's a fairly true statement. And if that's the case, those that have the ability to manage their information and extract value from that information, such as through intellectual property laws and regulations, but also within businesses, are most likely going to be able to deliver on the business plans of those businesses, whichever country they're in. And then my third point, I'd like to share how corporations rely on IP systems. And I'll put my second hat on, which is the Executive Vice President, General Counsel for Shell Oil. And I'll tell you a little bit about that and give you an example of how we use intellectual property in some of our large activities. Well, intellectual property is in the news. It's important activities for nations. You look at the change happening around the world. There are 5 major patent offices, and they are struggling to keep up with the volume of patents that are flooding out of businesses. Businesses historically are the engine for new technology, okay, around the world. Many of the major problems that we find facing us, such as energy sufficiency, food, water, climate, the public is looking to technology to solve many of these problems. And as you can imagine, it was stated by one of my colleagues in Shell that the effort associated with addressing the climate situation may require the amount of energy exerted by humans equivalent to World War II, which we know was considerable. So it is a very costly, it's a very challenging activity to make it happen. So it's not something that any one company or any one organization can handle alone. So therefore, we bring in the concept of partnering. Partnering is so crucial today, whether it's to develop complex new technologies, whether to mitigate the risk of those technologies, and how can we handle that? Well, when you partner from an IP perspective, there are many benefits, such as I've stated, new technology development, but there's also inherent risks to business. And those risks are classically known as in terms of 2 terms. One is termed leakage, and the other one is termed contamination. Okay? Leakage occurs when some of your technologists or business people end up having a discussion, and they're passionate about their technology. And you give them a cup of coffee, and they will tell you everything that they're doing. And hopefully it will be to your corporation rather than to your competitors. But there's no guarantees there. All right? So training is important. Contamination is another issue. On a global market, when you do R&D around the world, how do you know that the university you're working with, the companies you're working with, open sourcing, cloud sourcing for R&D, how do you know what you're being told is in fact the technology of that person, or whether it's part of a broader chess game where information is being fed into your multi-billion-dollar R&D activity that you've been working on for 3 years, so that a claim later on for ownership of patents in your technical area can be used to further cross-licensing negotiation at another point in time. This happens. So we have to be very astute in terms of how we partner. And I look very much to in-house counsel in corporations to be very knowledgeable about that. I had a rare pleasure of talking to the chief technology officer of a company, I won't give the name, but they're known to file perhaps some of more patents around the world than any other company, or at least within the top 5. And I said, well, why is filing so many patents important? And he paused for a moment in front of a big audience, and he says, it's not, okay? What we've delivered to all of the people in our organization is the idea that anyone can be innovative. Anyone can have an idea, whether you're in manufacturing, whether you're in sales, whether you're a technologist or a business person. And the second thing is, we teach them about information management practices and about IP. And because of that blend of innovation and IP, there's a natural chemical reaction that occurs, and it results in intellectual property. So he says we don't try and do it, it just happens. And so there's some good lessons to be learned. How do you create that kind of environment? Well, it's not an easy question. Okay, part of it is training people. Well, training is in most large corporations is not a term that anyone likes to hear because it interferes with your day job, but it's very important. And training in intellectual property is important. What happens when our technologist is at a conference with a business person and they're having their cups of coffee and they're chatting and they're sharing information? But in fact, they're not just talking about technology, they're sharing pricing information, they're sharing personal information about staff. If any of these things happen, privacy laws are violated. Of course, the sharing pricing information is antitrust problems. Multi-million-dollar fines are being levied against corporations for this kind of abuse. So the idea of training in compliance for information management as a formal activity is very important. But training by itself is not enough. If you're a global business doing business, you look at every country you're doing business in and you assess their intellectual property system, or at least I do. And that has, every country is on a different journey, and some are more advanced than others, but no one has yet arrived at where they will need to be. All right? So Russia's in the same point. I think every country of the world is. And so when I look around the world and I'm assessing national IP systems, there's a lot of room for improvement. And with the ICC, the International Chamber of Commerce, one of our primary directives is to help people of good minds and good hearts in our national chapters deliver messages that are important for that country, that come from thought leaders in that country, and provide an international organization support for those views so that they can then go forward into legislation and change. Now, one of the things that I look at from time to time is called, it's really an index of countries and how they're doing in terms of intellectual property. And this is an index that's online. There are other sources. Which source it is not so important, but if you come to me, I can let you know. But essentially what it does is it looks at 3 factors. and then it establishes a blended index, and then it ranks countries. And so it's not a bad way to, as a first data point, to begin your assessment of what risk you're likely to encounter in the national IP system of a country. And why, before I go into the index, which I know that you're all dying to hear about, why do it? Well, if you are responsible for managing the risk associated with a large project, one of the things that you're going to want to do, at least in the area of intellectual property, is be able to tell your business that for this bundle of technology, there's a value associated with it, and please, when you do the deal, keep that in mind and don't get any less compensation than that value. Sometimes they listen, sometimes they don't. But in calculating that value, you essentially begin with a net present value of a deal, and then you factor in various risks. And of course, the ability to have a strong, the benefits of a strong national IP system is a risk, and so that gets weighted in the valuation. So now in terms of the index, the three factors that it looks at are: how are physical property rights protected? Okay. How are intellectual property rights, focusing primarily on patents and copyrights? And last, the legal and political activity, including judicial independence, rule of law, political stability, and control of corruption. And from that, when you consider all of these factors, the index comes down with Finland coming out at top globally of the 130 countries at 8.6. New Zealand is next at 8.4. Sweden next, also 8.4. Norway, the Netherlands, Switzerland, Luxembourg, Singapore, Canada, and finally Denmark at 8.0. Broadly around the rest of the world, you're looking at the United Kingdom, 7.8. They're 12th out of 130. Germany at 7.7, 14 out of 130. The US, 7.6, 17 out of 130. Brazil, 55 out of 130. China, 57 out of 130. Now, in my business role, we have a lot of activity with Russia. And I have to say that while we don't have a lot of litigation from a patent opposition perspective, the system has worked very well for us. We happen to have gotten 2 good results, but of those 2, we thought that from a professionalism of the court, analysis, it went very well. So I would be very comfortable in using the courts for patent oppositions going forward. It's a learning process. I take, again, Mr. Drogzov's comment about patent filing. The question then becomes, how do you address patent filing, and how do you get the hearts and minds of your business community to start using the system more, to believe in it? And I think that there's a way to go in terms of PCT filing for Russia. There's a cost associated with PCT filing, but then around the rest of the world, there's not so much a concern about that cost, because in many places, many of the countries I've mentioned, an inventor who has been through the process before will have an idea. They will start the process for a PCT application. They will engage with a corporation with a confidentiality agreement in place, and the deal is that the corporation pays the cost and in return delivers a royalty to the individual or the organization. So this is possible, and with Russia's ascension to the WTO, this should be the expectation. That's the threshold. When I look at Russian corporations, you're a global player. WTO gives you not only the credentials to deliver intellectual property in sound business sense in Russia, but also the rest of the world. Okay. So, how then do we address the issue of intellectual property systems generally? How do we get to stronger national IP systems? Well, I would submit that there's really 3 components to a strong IP system, national IP system, and this is something that comes from the messages we deliver through the ICC. First is a recognition that there's a social contract, okay, between the inventor and the society they're in, all right, where for disclosure and doing all the work associated with the invention, they're going to get something back for it, okay? There's going to be either some recognition or there's going to be some kind of economic reward for all their trouble and cost. Second, is the existence of a clear set of regulations governing creation and implementation. And this is largely about the regulations, not just the laws that establish the patent offices, the trademark offices, copyrights, designs, trade secrets, but it's also the implementation regulations, so that my colleagues around the table, when they want to do business and they want to get intellectual property in the country of Qatar, in the country of Japan, they look to see a very transparent set of regulations, and they know if they follow that, they're going to be doing what's required. And last, but certainly not least, third pillar is the ability to rely on the rule of law. And this is important both to the enforcement rights through the court system, but also the general appreciation of the enforcement of contracts between parties. So I think that with those things in mind, we found that the social contract works. Every country is in a journey to improve on all of those areas, and the ICC stands committed to supporting that. Judge, how much time do I have left? Okay, let me, if I may just make one further comment. So putting on my hat with Shell. Shell is an oil and gas company. We have about $40 billion a year invested in capital expenditure. We make, in terms of revenue, about $450 billion a year. We have 25,000 patents, 45,000 trademarks, and roughly 20 to 25,000 trade secrets. So when I think of IP and my job as in-house counsel, it's really to not just look at patents or a distinct form of intellectual property, but it's to look at the bundle of patents, the bundle of trade secrets, licensed in rights, trademarks, and to the extent all of those can be defined to pertain to a particular technology that our business just wants to refer to as technology X or Y, I can provide that full bundle and the value of that. So when they do a deal with a partner such as Gazprom or Sinopec or any of the other oil companies around the world, we can clearly state what we have. Our business team knows what it's worth. And we do R&D on that basis. Most recently, we've created a vessel called Prelude. It's a half a kilometer long. It has a modularized liquefaction, natural gas liquefaction facility on it so that it can move from points to point in the ocean, extracting natural gas. And the intellectual property and how that's managed through very strict compliance-driven IP strategies controls the thousands of contracts we've entered into in the sense of what must we own in terms of IP, and used only within Shell, what must be owned but perhaps not all owned, so selective exclusivity. And then the third category is we really don't want to own any of the IP. Those three strategies carry through every business and R&D activity that we do in a disciplined process that if you don't adhere to it, you better be looking for another job. Ladies and gentlemen, thank you very much, fellow panelists.
Thank you, David. Judge Lynn is going to provide us with a brief overview of the U.S. patent system, including what government entities issue patents in the U.S. and how patents are enforced, including the legal judicial framework.
Thank you, and let me be brief because we have many things to cover, and I want to give others an opportunity to participate. But first, in the United States, the United States Patent and Trademark Office is the entity that examines and grants U.S. patents. They also examine and register U.S. trademarks. It has over 8,000 examiners. It's located in Alexandria, Virginia, which is a suburb of Washington, D.C. It also has newly opened or soon to be opened satellite offices in Detroit, Michigan, Silicon Valley, California, Denver, Colorado, and Dallas, Texas. The Patent Office receives close to 400,000 new applications each year, and in the most recent year, it granted almost 365,000 patents. Briefly, how patents are enforced. The patents are principally enforced in the federal courts. Around the country, there are 94 federal district courts. The district courts are the trial-level courts where patent cases are first heard. Appeals from those cases go to the United States Court of Appeals for the Federal Circuit, which is the court I am privileged to serve on. The Federal Circuit is the only one of the 13 appellate courts in the United States having jurisdiction to hear appeals in patent cases. And the losing party at the trial has an absolute right to appeal to the Federal Circuit. The party that is dissatisfied with the decision of the Federal Circuit can attempt to appeal to the United States Supreme Court, but they have no right to appeal. The Supreme Court decides which cases they will hear. And of all of the cases that are decided in the appellate courts around the United States, each year the Supreme Court only hears about 80 or 90 cases. Very, very few. So, for the most part, the cases decided at the appellate level are finally decided. As I said, the Supreme Court hears about 80 or 90 cases. This past year, of those cases, they heard 6 cases from our court. So they've become very actively involved in patent cases, and that's a recognition by our Supreme Court of the importance of intellectual property to the economy of the United States and to the global economy. The Federal Circuit, by the way, hears about 1,400 cases each year. There's another opportunity for patent owners to have their cases litigated, and that is before the International Trade Commission, the so-called ITC. The ITC is an agency, it's a federal agency. It's not a court. It has the right to prevent unfair acts in importation. Patent infringement is considered an unfair act in importation. So the ITC is empowered to make infringement determinations, and it's a very powerful agency in the sense that it can block infringing goods at the border before they even enter the country. Also, by law, the proceedings at the ITC have to move along at an expedited pace, and they're generally heard and resolved in about a year or a year and a half. Appeals from those decisions also come to the Federal Circuit, my court, and may also be appealed to the Supreme Court. Let me take just a minute to comment about the AIA, the America Invents Act, this sweeping legislation that was passed 3 years ago to reform and modernize our patent statutes that have been in place, in essence, from 1952. It did 3 things, essentially. One, it revised in small but somewhat significant ways almost every major provision in the patent code, designed to, again, keep pace with the changes that have occurred in the global business world. Now, The good news is that these changes are intended to modernize our system. And the bad news is that because no one now understands what these new provisions really mean, there's great uncertainty added to the law. And this uncertainty will remain for, I predict, at least a decade, because all of the cases have to be percolated through the system and come up to the Federal Circuit to get some interpretation before anyone really knows what these provisions mean. So the good news in that it's a modern statute, bad news, there's a lot of uncertainty. The second thing that it did was, and this is a very significant change, it moved the United States from a first-to-invent system to a first-to-file system. And right from the outset, the United States awarded patents to the first inventor. That was inconsistent with the way the rest of the world looked at things. The rest of the world, the first to file was awarded the patent. But in the United States, the first inventor, so that if there were two or more inventors that filed applications at about the same time, there would have to be an interference proceeding established in the patent office, and they were complex, sometimes lengthy proceedings. And that has been changed. And the real significance there is that now it brings the United States closer to harmony with the rest of the world. That has opened the doors to a lot of cooperation among various patent offices around the world. There are all sorts of new initiatives, the Patent Prosecution Highway and other initiatives where major patent offices around the world are now sharing workloads and responsibilities so that patent applications can be processed more expeditiously and efficiently. I think that's a major development. And the third thing is that the AIA established a number of so-called post-grant review proceedings. Before the AIA, the Patent Office processed applications, but once the applications were completed and the patent was issued, that was essentially the end of the Patent Office's involvement. From that point on, patents went off on their merry way, and if parties wanted to enforce them or if parties wanted to challenge the validity, that was done in the courts. Now, with the post-grant review, parties can go back to the Patent Office and seek to have the validity of these patents challenged and reviewed at the Patent Office. And the idea was, it was a recognition that even though we like to think that our legal system and our court system is one of the best in the world, it's not perfect. And the United States patent system, the enforcement mechanism through all of the federal courts is, and I'll be very candid with you, it's too costly, it takes too much time, and that's a very serious drawback. And the Congress recognized this and tried to provide an alternative path to getting validity challenges resolved in the Patent Office. The idea being that that on an expedited basis with somewhat simplified procedures, validity challenges could be reviewed at the Patent Office and save a lot of time and a lot of money. That system is in its infancy, and how it will work and whether it indeed will provide an effective alternative path remains to be seen. But those are the three major developments under the AIA.
Thank you, Judge. Now we're going to have an overview of the Russian patent system from Vice Chairman Kornev, and I'm sure that you will also participate.
Before Vladimir tell you about the Russian patent system, let me make a number of comments that on the presentations that we have heard already. I would like to pay attention to the fact that indeed the management of intellectual property is a whole branch of science which our businesses are not well versed in, and if big companies do understand full well how important this work is, small businesses, they don't have any knowledge about how they can protect their rights for intellectual property. Sometimes they are not aware that intellectual property objects exist, that they need to be protected, and they come across problems because someone makes a claim against this business that they use certain objects of intellectual property, make violations. And I think in the future we first and foremost should discuss the awareness raising in this field. As court employees, we come across directly with such situations where people coming to a court of law learn for the first time that they have infringed upon something. They learn about norms regulating some sort of relations. This is something that is absolutely new for them. We understand this problem full well, but very few people understand how profound it is. I would like to add a little bit on that by way of an illustration. People who write dissertations, theses on antitrust legislation, they call innovators those who infringe the rights of other right holders. They say they're innovators, they implement new things, but they hadn't done the patent search of what they are implementing, and it is not their fault that they were not aware that someone had invented this thing before. Even among the legal profession there are such opinions and positions. There is a right. If you have invented something, just check whether it hadn't been invented before or not. I liked your presentation very much, because you drew the attention to the necessity of managing such objects of intellectual process and business projects. If we trade in other objects, here the seller has to disclose the information on what he is selling on the market. While in the IP field, there is peculiarity. If the seller of innovations discloses what he proposes, no one will be interested because the information is already there. So it is better for him to hide this information, to conceal it for as long as possible, and the buyer, before he invests into this project, he needs to know as much as possible. And here we have this kind of frictions, and how can we strike a balance here for those who invest and for those who propose the innovative solutions? This is something that before was never discussed with regard to other objects. So how businesses approach the resolution of this problem, this is something that we will have to discuss for a long time. Now I will give the floor to Vladimir, okay? And then we will have... Vladimir, please, you have the floor. Thank you very much. In the course of my presentation, I will try to tell you a little bit the patent system in the Russian Federation. I will also try to divide my presentation into three parts. The first will be divided to the system of patents and patenting, and those tasks that the patent court has to fulfill. And then I would like to talk about the trends in the legislation a little bit, because there is also a presentation by Yelena. I would like to say a few words about what existing trends we already observe and what kind of trends we would like to see in the patent legislation field. I would like to start with patent system in the Russian Federation, about how our legislation is construed and what problems may arise here and do arise here. The issue here is whether to give a patent on an invention or an industrial sample or no, whether to provide legal protection for this trademark or that trademark. All these issues are now covered by Patent Agency. They have an expert. They provide an expert evaluation of the solutions. whether those innovative solutions comply with patent regulations. And these decisions on whether to grant legal protection or not, which are taken by Rospatent, whether they should issue a patent or not, whether they should protect a trademark or not. At present, these decisions cannot be disputed or appealed against immediately in a court of law. We have an administrative appeal procedure by people who are not in agreement with the decisions by Rospatent. Therefore, interested parties can go to the patent agency itself so that they could consider the objections against their decisions, say about the legal protection of a trademark. When the Intellectual Properties Court was set up, we had a very active discussion about whether we should retain this administrative stage in the line of appeals in cases related to the provision of legal protection. We discussed very actively the system of administrative appeals has a number of drawbacks, of which the main one is that the decision taken initially are reconsidered by the same body, and here may be doubts about the effectiveness of this procedure. What kind of body will be ready to recognize that its own decision is incorrect? In the course of a long discussion, we decided to retain the administrative situation, to leave the status quo for one very simple reason. The thing is that in the majority of cases, when we are talking about disputes or appeals against the initial decision, either to provide or not to provide legal protection, these disputes or appeals are heard on the basis of a new set of documents. If the patent was issued, then on the basis of documents that testify to the lack of innovations of this invention, the appeal is heard. And it was decided that it is very desirable that initially the entire set of documents about the provision of legal protection should be studied not by the court, but the patent authority.
And the Patent Office would review the documents not from the point of view of legality of the previous decision, but really does a new review on the basis of new substantive facts or documents. Overall, the system is quite efficient and is not drawing much critique, but when the system is inefficient, then you can go to an IP court, which would really consider whether a decision that was made would be legal. So the IP court was established indeed to review not any previous decisions or judgments, but decisions made as part of this administrative review process. The IP court, in this sense, is a unique court for the Russian Federation, and the uniqueness of this court is really explained by the reasons that caused this court to be established. The reasons are quite traditional for any countries that have the IP issues in mind, and many countries already have such specialized courts, and our court is not the first one to appear. And the tendency of having such specialized courts in the world would only be getting stronger. Yesterday, as part of one of the roundtable discussions where I was present, we discussed the issues of reception of different pieces of law. And the IP court is a good example of reception, because different countries come to recognize that they need to review the IP cases through different methods. Say, in the Russian Federation, the IP court was based on the expertise and experience of Germany and Japan. But in other countries, such specialized courts also take into account other experience. For example, even the experience of the Russian IP court. Many countries have become interested in our experience. So why would we have such an IP court in addition to a patent office? The idea is to discuss such IP cases not only from the point of view of law, which are important per se, but in some cases of more importance would be other issues. For, say, patent cases, it would be technological innovations, novelties, without any understanding of which it would be impossible to review such IP cases. And this puts them separate from any other cases, say, on trademarks. Of course, you need some knowledge of natural sciences or technologies, but not only that. It is not only possible to review them from the point of view of law. You need also to think, if you are talking about trademarks, about perceptions by the consumer. And this history of perception of trademarks by the consumer should be based on accumulated experience. You need to have some flexible mind and some particular attitude to trademarks, so that you can take a look at certain issues from the point of view of ordinary consumer. And of course, this necessitated to have a specialized court which would accumulate such experience. So in this sense, the IP court has certain tasks and goals in mind. Again, for the purpose of using specialized knowledge on, say, trademarks, previously, before we had the IP court, the most traditional institution that was used was the institution of expert examination. All patent disputes before the IP court came around always required involving experts and having an expert examination in the case. But in actual fact, all those patent disputes came to become some expert wars, whether the parties to a litigation would be competing for whoever expert would be better and accepted by the court. And then, of course, the expert in a particular field of natural sciences or technologies would be providing advice. And I remember a case which actually came all the way through to the Supreme Court. The case was about patent law. In a patent case, it was hepatitis B vaccine, and the expert and then the parties had two vaccines, but the vaccines actually only differed in the kind of yeast that they used to bring up the vaccines. And the question to the experts was whether those feeding stocks were the same for both vaccines or not. So it was nothing about patent law, but it was a question of whether those two types of yeast and feeding stock would be the same. So one expert said the properties are the same, another expert said no, they are quite different. So the court had to choose between two actual actually expert reports. So the first instance court chose one option, the second instance the upper court chose another expert, and they were arguing and arguing. So there was nothing about law in this case. So the IP court was established particularly for the purpose of trying to provide better quality of examination. So we have judges with, say, 2 higher educations or 2 masters. We have experts that can be involved in a case. We have the opportunity to involve third-party experts, not at the initiative of the parties to a case, but on the initiative of the court itself. When the court would think that there should be another third-party independent expert to be involved to decide. So, again, we see the need to use our own discretion or our own capacity to review the cases. Of course, also taking into account the facts of the case and the materials presented by the parties and the opinions presented by the parties. But the court must be quite eligible, or must be eligible in all these matters. Our court, in terms of our cases, our patent law cases, our court has for a long time discussed one subject. We need to have some uniformity of court practice. But this is topical not only for Russia but also internationally. The parties should really be sure and certain that there are certain principles in place that the court is guided by. And we really need to also think about uniformity of administrative practice. Alexander mentioned here that we have some deteriorating quality of expert examination in reviewing the cases. I don't think that it is deteriorating. Indeed, we have some deficiencies. We have some deficiencies in the initial assessments, and the court face some challenges, maybe not on a daily basis, but on a weekly basis for sure. And this is not only true for patent cases, but also for trademark cases. The patent office, when it issues a patent or refuses to issue a patent, is looking into the same norms and standards of law, and in the similar circumstances you would have different decisions saying that each application is reviewed on a case-by-case basis and there is no administrative precedent that can be applied. You can agree, of course, that there should be a case-by-case approach based on the circumstances of each particular case, but the principle, the fundamental principle for a decision should be there. I remember a case not from the patent case but from a trademark case which was reviewed by our court when we reviewed 2 descriptions. One description or designation was legally protected by the patent office. That was about goods of the so-called 5th category for the use of in sports, and there was no protection for the term for sports of this part of the description for sports. However, it was protected in the English description of the product. The circumstances were the same from the point of view of perception of the customer, be it a description in English or in Russian. For the most of the customers, the product was perceived in the same way, and you would think that there would be the same approaches, but it was not the case. And also in the patent, in a patent case, in actually IT, we revealed that there was some notion or certain issue about patent law, and those aspects of the patent law were actually perceived and decided upon differently by the Patent Office. So the IP Court sees its task in providing uniformity of understanding by different authorities in reviewing the cases, not only in court but also in the Patent Office, so that the parties to a dispute would be sure and certain about the principles that are used by the Patent Office to make a decision. That was my first part, secondly, I would like to briefly discuss the trends, not of the court practices or of the IP court itself, but of the general trends and tendencies of legislation. I would say that the IP legislation and its development, I think, clearly indicate that there is a link between the legislative process and the court practice. Because what we have now in terms of legislative development, also Part 4 of the Civil Code, which was put into force in 2007, and now that we already have some forthcoming changes and amendments, and such changes are made not for the sake, not because the legislator really wants to change something, or, I don't know, implement some new ideas, but these changes are necessitated by court practices and the need to harmonize our legislation with foreign legislations in line with our international obligations. One of the main challenges that we revealed was the need to find a balanced solution between the right holders and third parties. Also in terms of providing legal protection to the IP products, but also providing a uniform approach, a balanced approach to handling infringements. So we are trying to find a balance, and we, I think, face the same challenge as in other countries, because again we're talking about responsibility. Our responsibility, on the one hand, to compensate and remunerate for damages of the right holder, but on the other hand, we don't want to harm and damage third parties. And this means then that we need to have some balanced intermediate solution. In terms of trends, what we would like to see, just briefly discuss our aspirations. For some reason, in modern Russia, it has been for a long time that academics and courts have recognized that the IP legislation is a separate field of law, which is independent, totally separate from civil legislation. And the idea was caused by the fact that we had special laws without any reference to the civil code, special laws on IP, and also the IP, the intellectual property, is somehow put separately from any other civil legislation and rights. So, indeed, our courts, including our Higher Court of Arbitration, had to do something to overcome this, to equalize IP and other civil property rights. I think that we already have the radical solution there, where the intellectual property aspects are directly included in Part 4 of the Civil Code, and that is, they're covered by the civil legislation. But we need to take another step forward. It is not only for the lawyers who are dealing with IP that should really perceive IP as part of the civil legislation, but it is also for any other specialized lawyers to have the same understanding, also in terms of lawmaking and also in terms of law enforcement. Undoubtedly, when we're talking about some norms of general civil legislation, people think about property laws and are not really thinking how such property laws would be applied to intellectual property. But equally, the court practice shows that there is some interpretation of general civil law matters, but the authors of such positions or attitudes really see in front of them something from the domain of simple property law without thinking how it would affect intellectual property, although the institutions are the same for the civil legislation and for the intellectual property. In terms of legislation, registration requirements have recently been changed, and Part 1 of the Civil Code, you don't see much balance between the property registration requirements and intellectual property registration requirements. And some courts decided that property registration aspects would not be covering intellectual property registration requirements, or say trusts. You might think that you can still apply any provisions on trustees and trusts to intellectual property rights, but not always. Or take the rights of heritage on intellectual property. Again, here we see some imbalances. For example, the Supreme Court provided clarifications on a situation when you have some trademark inheritance, and the one who inherits is a physical person, but not a sole proprietorship. And in the Russian Federation, the trademark can only belong to a sole proprietorship, not to a natural person. So the Supreme Court really clarified that a natural person can acquire such intellectual property, such trademark, for the period of 1 year, during which this natural person must become a sole proprietorship. But again, if the civil code says that if this trademark does not belong to a sole proprietorship, even during this 1 year grace period, anyone can claim this trademark because it seems to belong to nobody. So we need to really harmonize this intellectual property provisions with the rest of the civil code.
Thank you, Vladimir. In his presentation, Vladimir highlighted some of the most challenging issues currently, issues that are related to the development of civil legislation. And for us, intellectual property legislation is basically part of civil legislation. When we adjudicated cases, the first thing that we ran into was not really related to the application of specific provisions of Part 4 of the Civil Code, but rather the general misalignment between these provisions and the general civil legislation. Therefore, we recognize that we need to go back to the drawing board and address these inconsistencies. I would like to draw your attention to another aspect also, because we believe this is very relevant for the Russian participants who are present here. Our IP legislation keeps changing, and this is a very, very intensive evolution process. However, what about the debate surrounding these legislative changes? In my opinion, this discussion is sort of a one-way street. Without any prejudice to the protection of rights holders' rights, I think we also need to have a balance whenever we deal with specific situations, so that we take into account not only the rights holders but also the interests of third parties and the interests of society in general. Sometimes this balance somehow falls through the cracks in our discussions. Who is going to physically represent the interests of society in these discussions? Who is going to undertake this mission to represent or formulate, nail down the specific interests that society and the public have? So we are in a situation where we have one voice that is very strongly heard, but the other side does not really have a voice, which sometimes results in lopsided provisions, imbalances that will have to be retroactively addressed. And the case in point is compensations. My colleague mentioned it already. This is a new tool, which is a very effective tool, and it has proven to be quite effective. However, for the purposes of practical application, when this tool is used, very often it is very critically received by a very wide public, really, because the situations sometimes look completely unfair. The decisions that are made by courts in strict compliance with the law are perceived by the public as unjust and unfair, which seems to indicate to me that we need to address this imbalance sometimes and look at the other side as well. I'm sorry, I have abused my position as the moderator. I think I now need to turn it over to Elena Alexandrovna, because when it comes to legislative improvements, she's your speaker. I'm afraid that we may go over the time limit. Well, we still have a little bit of time, but you know, we are experts. We can say a lot of things using very few words. Well, I will really try to reduce my presentation. Now I have some slides that I would like to show you. How do I turn? Alright, so initially I wanted to dedicate my presentation to the challenges and issues related to the latest changes to Part 4 of the Civil Code, which partly deals with intellectual property. The latest law on that subject was passed on the 12th of March 2014. Its provisions come into effect from the 1st of October 2014, with the exception of certain rather complicated provisions which require enabling legislation to be adopted before they can come into effect starting the 1st of January 2015. So let me give you a few cases, a few examples that illustrate what Vladimir already talked about when he said that there needs to be some alignment between the provisions found in civil legislation in the classical parts of our civil code, the first three parts, and on the other hand the specific provisions contained in the recently adopted Part 4 of the Civil Code. That part is in effect since the 1st of January 2008, and we have seen some lessons learned already from their application, lessons that have to do with some basic general issues. It has been mentioned already that property rights are distinct from intellectual property rights indeed. And this is very important. We know that there are proprietary concepts in this field. Many European continental countries are usually guided by the provision that there is no basic difference between intellectual property and property in general. However, for us, this may be a problem. Perhaps this is a legacy of the Soviet past, but we have some limited property rights, such as the right of operational control in the case of public establishments. and lots of public establishments such as government maintained research institutions, for them it is very important. Sometimes people believe that the inventions and intellectual property developed by those organizations belong to them on the basis of their limited right to operational control, even though these institutions are the authors, the generators of that intellectual property. This is really a misconception, because they, as right holders, are fully entitled to use these rights and exercise them. So, a lot of misconceptions. This is why Article 1227 of the Civil Code, that initially contains a provision that draws a very blurred dividing line between material carrier rights and intellectual property rights per se, now contains a new provision that says that intellectual property rights are not subject to Section 2 of the Civil Code that talks about property rights unless otherwise established by that particular by Section 7 of the Civil Code, which takes these provisions outside of the property right provisions per se. And there's a negative aspect here, because by analogy, other norms cannot apply here. And if we want some property provisions to be applied to intellectual property, we need to work within Part 7 that talks about intellectual property rights and modify them accordingly. Can you change the slide for me, please? All right. In a nutshell, the next idea is we tried to address the question concerning the shares of ownership within this right. We proceed from the understanding that the intellectual property right is indivisible, but there can be several rights holders involved, and they should have the right to exercise that right jointly whenever necessary. In the initial version of that provision, it talked that this right can be exercised jointly, and other provisions can be stipulated by the Civil Code. There was no optionality about that provision. In the draft changes to the Civil Code, there were several options proposed to address the situation whenever the author or the rights holder wants to exit the group of rights holders, or perhaps to reassign their share of that right to somebody else. However, as a result of consultations around that draft, we decided not to change the provision because there were too many counter-arguments. We decided to establish optionality or dispositivity, which means that the right can be jointly exercised unless otherwise stipulated by the code or by the contract between these parties. In other words, co-holders of the right can make an agreement, and if they elaborated in sufficiently, they can divide between themselves the shares in this right. So we cannot apply mutual ownership provisions to intellectual property. We need a separate set of provisions in Part 7 for that. And another example comes from has to do with state registration. Article 8.1, which has been reintroduced into the Civil Code, provides a general rule on state registration of rights. But by these rights, it certainly implies immovable property rights in the first place. Article 10 says that Article 8 shall apply unless otherwise provided by the Civil Code, and that is a silent reference to Part 4, because Part 4 contains rules concerning state registration of various intellectual property assets, for which it is mandatory with respect to inventions, industrial designs, utility models, and trademarks. And Part 4 contains rather different rules that are not very well aligned with Part 1, Article 8 Item 1. With respect to already registered assets, there may be problems with whether or not reassignment of rights needs to be registered. Article 8 of the first part may be partially applicable to that, even though intellectual property is somewhat different at all. This is why Article 1232 of the Civil Code contains a provision regarding the procedure, the special procedure for state registration of rights reassignment, the use of rights as security, as well as the award of the right to use under a licensing contract. Therefore, this specific concrete article is rather consistent with the rest of the Civil Code, because in the Civil Code there has been a transition from registration of transaction to the registration of rights. In other words, we are not registering a reassignment or licensing contracts. What we register is the right. It's not a license agreement legislation, but rather the registration of a reassignment of right to the licensee. In other words, there is some consistency, but there is also inconsistency, because there are some concrete rules that are not the same as in Article 1, and that has to do with the examination procedure. Applications can be filed by any party of the agreement or by one party only, and there is also a specific list of the documentation that needs to be provided, as well as the information to be contained in that documentation. At the same time, we also comply with the Singapore Treaty on Trademarks, because in accordance with that treaty, the contract need not be provided for registration. And that also changes the implication of that provision. Earlier, in compliance with registration, rendered the contract invalid. Now the contract can only be invalid if it is not in written form. If the contract has not been registered, it does not change the situation. If, however, there is no registration of reassignment of right, that renders the right invalid. I'm not going to trespass on your time, and I would like to leave it there. I will try to share my presentation with the rest of you, so if you're interested, you can get more details from it.
IP law as applied, and call on our representatives of U.S. business. We have two lawyers, David Leach, the general counsel of Ford Motor, and Michael McGrath, the senior counsel with General Electric, to talk about some of the problems that companies face when they try and get the laws that are on the books enforced. David, do you want?
Happy to start. Thank you for inviting me here, and just an observation or two about what has been said to this point. President Novoselova, you said that the IP system is being created before our eyes, and I think it's a very exciting thing to behold. As Judge Lynn observed, we've had the IP system in the United States since our Constitution was adopted in 1787, and we continue to create it before our eyes. And so these opportunities to exchange information and learning and experience are very valuable to all of us. And just as you may observe what we've done, both best practices and mistakes, you get to write on a relatively clean slate, and congratulations to you and your court for its initiation and successful beginning. I would also just comment, we've heard a lot about incentives today, and you asked a couple of very good questions, I thought, along the way, which was, how do you get the inventor to disclose his innovation and trust the party on the other side so that that information becomes public? And then you also ask, who represents the public? What is the public interest, and how is it represented in this in this system. And I think that's the very beauty of the patent system, is it's a trade-off between the inventor and the public that says we will give you exclusive rights for a period of time if you disclose your invention so the public can be aware of it and build on it. And so the beauty of the patent system is that it answers those questions very nicely. We may have to adjust the bargain from time to time. What's the right period of time? Is the disclosure valid? Is it sufficient for the purpose that we want the public to know what's out there? But the very fundamental nature of the patent system, I think, answers those questions in a really beautiful way that can be adjusted to the circumstances in each society and in each circumstance, and could be different for different kinds of technologies which develop at different speeds. So, in any way, we've heard a lot about incentives, and I think those incentives are at work in the patent system. In terms of how it works in the real world, we have some experiences where the enforcement of patents in various systems is not what it could be or should be. I'll give you the systems that are on the books are not necessarily the way things work in the real world. And I'll give you an example from our own experience in the United States, where in the statute, attorney's fees are theoretically available to a party who has gotten charged with infringing a patent that turns out not to have been true. The U.S. system, of course, is generally that each party pays its own legal costs, but the Congress adopted an exceptional case exception for allowing courts to impose attorney's fees as part of the cost on the party who has not prevailed in the action. And in reality, this almost never occurs. And we've had some developments in the U.S. Supreme Court recently where they have clarified that the exceptional case standard is perhaps not as rigid as some had thought or had been in practice. So we may actually have some circumstances, particularly as we have more and more experience with non-practicing entities, where frivolous assertions or widespread assertions of infringement may be reduced because of the ability to collect attorney's fees. It will take a while for that to work through the system, but it is a case where what has been on the books has almost never been enforced or applied in cases in the real world. And those of us who are on both sides of that litigation equation sometimes feel that, of course, all of the things we assert are completely justified, and all of those asserted against us are frivolous. But we do feel that responsible players in the system will benefit from a system that sometimes enforces these attorney's fees provisions. So just one example from our own experience where perhaps the as-applied law is not quite as favorable or as consistent with what's written on the pages of the statute book. So, Michael, I'll turn it over to you for a few words. I know we don't have much time.
I'll be very brief. Thank you. First of all, spasibo большое. Thank you for having us for organizing such an event for us. I am not a patent or even intellectual property specialist. My position within the General Electric Company is dispute resolution, litigation, mainly outside of the United States. And so I'm not typically involved in such high-level and esteemed presences. I'm the person who goes to the courts and actually interacts with the judges. And I've been doing this for about 15 years with the General Electric Company, mainly for the oil and gas division, in which we have a very significant relationship and presence here in Russia. Over those 15 years, I should note that for a technology company, and make no mistake, when you hear General Electric, many people think of light bulbs and washing machines, but we are in fact we make turbines and aircraft engines, locomotives, rail systems. We are at the end of the day a company that is built on innovation. If we could not innovate and make money on innovation, we would not exist. And yet we've existed for over 100 years, and we will be around for another 100 years, in large measure also because of initiatives like this that allow us to grow. Today, most of GE's growth is actually not in the United States. It comes from outside of the U.S. By far, most of our revenues are derived from around the world, which means that, as I've seen my docket of litigation of disputes grow over the years, I notice that intellectual property disputes, not just patent disputes, but intellectual property disputes of many types, are increasingly a part of my docket. Trade secrets is an area that comes up very often, and I think is a good example of where, and there's a theme that I've noticed in many of the presentations, and I just say that many of the speakers from the Russian Federation have stolen my thunder because they have emphasized the point repeatedly about, about awareness. Judge, you mentioned, awareness raising, and the notion that you're creating a system. I think what you really are, and what we're always seeing, is the creation and recreation of a culture. It's a judicial culture. At the end of the day, all of these initiatives, all the legislation can be passed, but if the judges don't actually understand and appreciate the value, and I was going to share some examples, but I won't get into details because of the lack of time. But we've seen examples within certain countries, and I can share just very quickly a couple cases in Italy where we've had identical cases of intellectual property being stolen from the company, of trade secret theft. They went into the newspapers, was on national television, and we've got very different results in different cases where our intellectual property or trade secrets have been protected, and others where it's not. And the only thing that really changed in those cases were the human beings involved, the judges. So I think, and I say this to all participants, not just to Russia or just America, but I think countries in generally really need to focus on the quality of the legal culture that is created among the judiciary. We often, in our in-house counsel, complain about the inability that we have to speak to judges like this. It's really a rare opportunity to be able to address a judge and say, this is the world that we see, this is how we survive, this is how we live. When I meet with judges, typically it's be told, you're right, you win, you lose, and to speak in this forum is a true opportunity. And I think that one of the trends that we have seen as a way to help companies like us grow is actually, I think Russia is on to something, and I think that you mentioned it in your presentation, this notion of specialized courts. It is seen, we've seen not only in intellectual property, but in many branches of the law, that as the legal systems become more sophisticated, as they become more robust, we see that they have courts dedicated to resolving disputes over commercial matters, sometimes subcategories of commercial matters, sometimes just about issues of arbitration, for example. So to the extent that I think Russia and other countries are able to follow the model of specialization, of having people who repeatedly are engaged in the same process, I think, to David's point, the rule of law becomes, rule of law at the end of the day for us is predictability. We need to be able to estimate, understand, will our rights be respected the next time our issue comes up? And I think that this is certainly, is definitely the right direction that for companies like us to be able to partner and grow and to become part of the innovation within a country.
What, do you think we should end, or?
Уважаемые коллеги,
Esteemed colleagues, usually during such sessions you think that, well, we must be on time this time, but every time we are not on time. Unfortunately, our organizers are asking us, because a new event is going to be here, they are asking us to try and wrap up our discussion, but of course the discussion never stops. I would like to thank you all for participating. I would like to apologize before Vitaly because I could not give you the floor, but maybe if you don't mind, it won't be fair. We are all for fairness here. Probably we should give the floor to Vitaly. He's a specialist of the highest caliber, and if we do so, it will be correct. And then we will sum up our discussion. And I would like to tell our participants that we are prepared to answer any questions, but since the format is like this, we will continue talking to you in a less formal setting. Vitaly, please, you have the floor.
Постараюсь очень коротко, тезисно так осветить то, что я хотел сказать. А хотел я сказать о том, как законодательство надо развивать, исходя из того вот этих тенденций будущего и того, куда мы хотим прийти. Иначе говоря, наше видение должно быть трехмерным. То есть мы должны представлять, что у нас...
Our vision should be quite clear. We need to understand the legislation that exists around us. And my topic is digital use of intellectual property. Historically, intellectual property was a reaction to specific issues. Now we have these general norms that gives us an opportunity to react to any situation that may arise in the future. Article 229 says that the owner of the right controls any use of IP, and we can control everything in digital form. At the same time, there are a number of special cases that are related to copyright, that are related to domain names, and the norm that we have in Article 1270 is sufficient for copyright, but something is continuously changing. Today we already said that we have had a clarification for digital forms of using IP. The cases of free use of IP, when Internet was equalized with other mass media. Unfortunately, we could not fully resolve the problem of electronic libraries, this was mentioned before here, and about technical means of copyright protection. This is a significant change on that front. What do we need to do further? So we need to them must regulate internet sites, must regulate e-libraries in the field of patent law. Russian Federation is currently lagging behind in what refers to patenting information object, business processes, software solutions, informatization of resources, domain names, and finally we must come to an international agreement which will somehow streamline these issues. The second row of issues is the discharge of those rights, the use of those rights. Over the last round of changes, we have introduced such a notion as an e-transaction. We borrowed a lot from foreign legislation, a new law on electronic signature, which is up to date. And at the level of the transactions, we could say that the issue is more or less covered. But at the same time, there are subsequent problems which lie outside civil law. The protection of consumers in international disputes, and the last level is the distribution of responsibility or liability. Here we are mainly guided by case law, but it is not entirely satisfactory. Those cases that were ruled on are quite doubtful and cannot be a full solution. The situation of conflict exists there, and the anti-piracy law we adopted last year, and we can only consider it only as a temporary solution. It has given some guidance as to how to move forward, but it is quite clear that this is just the beginning of a road. I try to give you a big overview of what existed before, what we have now, and what is in the future. I told you that real experts can give you a lot of information within 1 second, literally. Thank you very much to all the participants of our roundtable. I hope very much that our experts will provide their presentations for publication, which will give us an opportunity to study their positions in greater detail, and let us continue our discussion at a cup of coffee or tea, and I would like to invite all the participants in the room to stay. I would like to thank the interpreters also.